lawyers alone, it's the only private profession in our country that swears an oath to the Constitution. So I think lawyers in particular have to play a key role in really arguing for support for the rule of law, regardless of whose ox is being gored in a particular moment.
Hello, everybody, and welcome. My name is Gregg Nunziata, and I am Executive Director of the Society for the Rule of Law Institute. And this is our weekly podcast, Checks and Balances, where every time we get together, we talk about some of the biggest challenges facing the rule of law in the country today, new court cases, and big legal stories. And today, I could not be more pleased to welcome my guest, Justice Clint Bolick of the Arizona Supreme Court. Justice Bolick has been on the court for about a decade now, and prior to joining that court, he had a legendary legal career in public interest litigation here in Washington and beyond. He served as vice president for litigation at the Goldwater Institute and as co-founder and vice president for litigation at the Institute for Justice, which, full disclosure, employed my beautiful wife for about a decade. So we feel very, very warmly about the Institute for Justice here in the Nunziata family. In this time in private practice, Justice Bolick litigated in support of school choice, freedom of enterprise, private property, free speech, federalism, and against racial classifications and government subsidies. Before ascending to the bench, he also was widely published in articles and at book length, and he continues to write and speak today. He's really become one of the nation's leading voices defending the rule of law and our Constitution. So thank you so much for joining us today, Justice Bolick. I couldn't be more pleased.
Greg, what a kind introduction. It is great to be with you, and I'm embarrassed that you have Goldwater memorabilia behind you, and I do not, notwithstanding purporting to be an Arizonan. So
it's never too late. Well, thank you for being here. Here's what I want to do today. I'm just to talk a little bit about your career and particularly some of your advocacy for the rule of law and the principles that are so important to kind of our organization and really to all American citizens. But let's just first talk about your job. I think that maybe lawyers, of course, understand how important state courts are, but maybe not every American does. So much of the news is focused on this U.S. Supreme Court and the federal judiciary, but most cases and most disputes between citizens and their government are adjudicated in state courts today. Property rights, criminal law, family law, much of this is more in the state courts than they are in federal courts. So when people ask you kind of what is your job, what do state courts do, what is the importance of a state Supreme Court, how do you explain it to them?
Well, we are the final word on the interpretation of state law and our state constitution. My friend in Ohio has written some incredible books on state constitutional law. That is Judge Jeff Sutton on the Seventh Circuit, and he's pointed out that we don't just have one constitution, we have 51. And so the state Supreme Courts are the final word on state constitutions, all of which provide greater constraints on government power and greater protection for individual rights than does the U.S. Constitution as interpreted by the U.S. Supreme Court. So that's, I refer to that generally as state constitutionalism. And unsurprisingly, I have been a very strong proponent of the independent interpretation of state constitutions. If we ground our decisions on the state constitution and a federal issue is not presented, then our decisions are unreviewable by the U.S. Supreme Court. So that's what I mean when I say the final word on those issues. And we also often interpret the federal Constitution as well. Just to give you an example, one of many, before the U.S. Supreme Court issued its decisions in the area of mandatory speech with regard to the rights of gay individuals, we issued a ruling in a case called Brush and Nib, arguing that the government could not compel individuals, in this case calligraphers, from providing custom-made products to gay couples when that violated the religious beliefs of those individuals. And that decision ultimately the U.S. Supreme Court agreed with, but we made that decision, and if the U.S. Supreme Court had gone in a different direction, that would still be the law of the land in Arizona, because we were providing greater protections for individual liberty than the U.S. Supreme Court. Same thing in the area of eminent domain, which was an issue that my colleagues and I litigated at the Institute for Justice. The U.S. Supreme Court decided Kelo versus City of New London, where they rewrote the Fifth Amendment of protection and did away with the protection of public use, that government can only take private property for public use.
So in Kelo, the town was taking this woman's house for the purposes of private development.
Exactly. Yeah. And we came to a contrary ruling here in Arizona, and many other state Supreme Courts did similarly. And so we actually have greater protection for private property rights here in Arizona and in some other states than under the Fifth Amendment. So you can imagine for someone who comes from a libertarian political philosophy, that's really wonderful terrain. It does mean that often I have to interpret a progressive era constitution in a way that is contrary to my own political philosophy, but that's what the rule of law is all about.
Yeah, I think this issue with how the federal Constitution, I think you've put it as it just provides the floor for the protection of our liberties. I think this surprises people. I think I saw maybe it was just last week, the Pennsylvania Supreme Court had an important ruling on the searches of private property and search of land, coming in with a more protective ruling than the federal judiciary has. Do you think that citizens are aware enough of this fact? Are litigators and public interest litigators enough about it? Aware enough about it? Does the Academy pay enough attention to state constitutions?
Emphatically no, Greg. And in fact, really, this was a mystery to people until Justice William Brennan wrote about it in a pair of law review articles in the 1970s and 80s, basically urging advocates to look to state constitutions to protect individual rights. At that time, he believed that criminal justice rights, criminal defendant rights, were being eroded by the U.S. Supreme Court, and so he urged liberal activists to go to state courts. But he made the point, this is not just a liberal prescription. There are many rights that conservatives hold dearly under state constitutions as well. And it really wasn't until this century that conservative groups, including the Institute for Justice in the eminent domain area, began looking to state constitutions as well. And now both liberals and conservatives do it to a significant extent, but not nearly enough in my view. And the reason that they focus on federal jurisprudence is you can, with a single decision, of course, establish a legal principle. But if you don't want to subject yourself to the ebb and flow of federal jurisprudence, state courts are a very, very important place, and especially for people on the center right, This is an attribute of federalism. And it's an attribute of federalism that that center-right attorneys just didn't really fully vindicate or discover until recently.
Now, this is going to get maybe in the weeds a little bit, but obviously state courts might provide, state constitutions might provide greater rights to citizens because they're different documents. But sometimes you have the same phrase from the federal constitution and the state constitution, and the ruling comes out differently. Now, is that the product of simply different personnel on the bench, or do you interpret the state constitution differently than the federal constitution? And if so, how or when?
So that is an area of very active dispute among academics and among judges. Just to give you an example, the Illinois Supreme Court has long held that the federal constitution and the state constitution, that they should interpret the state constitution in lockstep with U.S. Supreme Court decisions. And I couldn't disagree with that more strongly because, you know, the U.S. Supreme Court changes its mind. And if you're hitching state constitutional interpretation to evolving federal jurisprudence, then you're letting the U.S. Supreme Court essentially amend your Constitution. And as I have pointed out a number of times, state judges take an oath to the state constitution as well as the federal constitution. Federal judges don't. It is not their responsibility to look into what the state courts meant or the state constitutions mean. So I think that it's very important. If the language is identical, my view is that you should look to the interpretation of the U.S. Supreme Court of the similar federal language at the time that the state constitution was adopted, which for us is 1912. Presumably, if our Constitution's framers adopted identical language, you can presume, I think safely, that they intended to incorporate federal constitutional jurisprudence from that time, but not giving license to the U.S. Supreme Court to define our constitutional guarantees. And that's come up a few times since I've been a justice, and I suspect will continue to present itself.
Okay, well, let's talk about something else that's different about the state judiciary, which is how you become a judge. I worked for years doing federal judicial confirmation proceedings in the Senate, so I'm biased maybe towards the federal system, but I guess it's always been surprising to me that very few states, I think maybe only New Jersey, approximates the federal approach to judicial selection and appointment. I think the other big models are election or merit selection, and there are different versions of each and blended versions of each. What is the system in Arizona, and how has it been working out?
So we have a merit selection system. So the judges, anyone can apply for a judgeship here in Arizona so long as they meet the constitutional requirements. And then we have merit selection commissions comprised of both lawyers and non-lawyers that must be bipartisan. And they present for every opening to the governor a list of at least 3 names, and that list in turn has to be bipartisan as well. And the process, I chair the Maricopa County Superior Court Nominating Commission. The process is about as rigorous as it gets. And one of the things that I love about Arizona is if you've been a jerk as a lawyer, you are not going to become a judge, because everyone, the commissions call everyone that you've ever litigated against, and they get to weigh in on your nomination. So it could hardly be more different. The federal system has an aspect of that. There's definitely a due diligence aspect to it. But the election process, which is, I think, 180 degrees from the merit selection, really doesn't have that. It's truly a campaign process. And with merit selection, you have to run for retention periodically. And I have survived, and I use that term literally, two retention processes here in Arizona. But I've litigated in states like Texas and Wisconsin, which have election systems, and they're terrible. Tons of out-of-state money roll in, and who do the judges have to ask for money? The lawyers who appear before them. I remember a hearing in Texas when I was at the Institute for Justice, where it was just a routine status conference, and there were lawyers from with all sorts of cases gathering to have their hearings, and the courtroom was abuzz with conversation about whether everyone was current in their campaign contributions to the judge in front of whom we were about to appear. We were not current in our contributions, and we lost. And whether an appropriate outcome or not, you have to wonder whether the fix is in, and that's horrible. Huge issues are decided in these judicial elections. When we were litigating school choice in Wisconsin, I would have to look at the election returns for the Wisconsin Supreme Court to know whether I had a good chance or not. And that's a terrible, terrible system. By contrast, our system, we are constantly reviewed by the people who appear before us. That those surveys are in turn made public, in my most recent retention, when a number of activists came out against my retention, it was really gratifying to be able to present the surveys showing 98, 99% of the respondents thought that I was a judge of integrity, that I was a judge who wrote very good scholarly opinions and that sort of thing. And it was nice to be able to counter the ideological advocacy with the neutral surveys that come out.
I want to get to the recall question in a second, but one more question on merit selection. I've also been a longtime critic of judicial elections, but it does seem to be the preferred model of many people on the right. I think there's a feeling that merit selection favors the left, or it creates an insular, self-serving bar and judiciary. Are there key features you think states should have in mind when designing merit selection to make sure it works the way it's intended and doesn't become the caricature of it that its critics have?
Absolutely. And the key thing is to make the state bar's role as little as possible in the process. They should not be appointing people to the merit selection system. They should not be the entity that evaluates judges. And I think there is a high correlation between dissatisfaction with merit selection and the role that the state bar plays. And our state bar plays almost no role in either the merit selection initially or in the evaluation of judges. So I think Arizona's system has really been exemplary. And in fact, when I got married in the year 2000, and my wife was saying we're moving out of D.C., Arizona really, and she said, we're moving someplace where it doesn't snow. That really narrowed down the list of possibilities. And I had litigated in Arizona, and at that time we had Democrat governors in this state for a lot of the recent period. But I thought that the judges I appeared before in Arizona cases were fantastic. Didn't matter whether they were Democrat appointees or Republican appointees, and it was because of the merit selection system. And I have become a very, very strong supporter of version of it. I agree with you. You know, when I go to Federalist Society events, they have debates between whether it should be elected or whether it should be the federal system. And they don't even talk about merit selection. And, you know, when you look at the amount of money that was spent in the most recent Wisconsin Supreme Court race, $50 million, and the center right lost, and it is now a liberal court. Michigan used to be a conservative court and now is a liberal court. You know, certainly Texas and North Carolina, which are elected, are conservative courts. But you know, you really are at the mercy of political action committees, of lawyers, and I really like our system.
So you mentioned that you survived recall elections, and the most recent one was really a nationally watched race because your court issued an opinion in an abortion-related case about, and essentially the ruling was if the state wants to change the law, the legislature has to change the law, right? But it was extremely controversial and got activists fired up. I guess I'd be happy to hear about your personal feelings through that experience, but in particular, I wanted to mention an op-ed which you wrote at the time. And the headline, I don't know if you wrote the headline, authors often don't write headlines, but the headline was, "I don't need to be a Supreme Court justice, but Arizona needs the system that got me there." And it was really a stirring defense of judicial independence, which has been under attack from every direction for the last few years. So can you tell us a little bit about why you wrote that piece and the issues that were at stake for you in that recall campaign?
No, and by the way, just to get the terminology right, it was not a recall, it was
retention. Retention.
Yeah. And we do have judicial recall, which underscores how independent Arizona is. When we applied for statehood, President Taft vetoed statehood because we had a judicial recall provision in our proposed constitution. And so we got rid of that provision. We then got statehood, and the very first thing that Arizona did after it was a state was to put that back in the Constitution. So we do have a judicial recall provision, but retention is just a normal, you know, every 4 years for trial judges, every 6 years for appellate judges. And you're absolutely right. It was an abortion decision. It was a statutory interpretation ruling. Even liberal academics thought that we got it right, but it was incredibly controversial and, in fact, was overturned by a new abortion provision that exists in our state constitution now that guarantees the right to abortion. So my colleague and I, both of whom voted in favor of the decision that caused all the consternation, we were on the ballot at the very same time as this abortion provision. And one of the things I think speaks so well to judicial independence is that provision passed, the right to abortion, and we were both retained, which means that about 20% of the electorate had to have voted both for that and for the justices who, you know, had issued this ruling. And neither of us had a campaign because my colleague and I both felt that we didn't want to ask people for money for a judicial retention campaign. And so there was an independent expenditure committee, and their entire campaign was based on judicial independence and keep politics out of the courts. And the electorate responded overwhelmingly. I won with 58%. She won with 59%. I told her she ought to run for governor after doing so well. But it really was a wonderful vindication of judicial independence and showed that the electorate could be extremely sophisticated in voting on both of those measures. But I wrote that piece, it was good that I was one of the judges who was caught in this maelstrom, because I had experience in the public arena and I wasn't afraid to assert my free speech rights and to just say, listen, if we lose this retention, two judges who were highly rated by the people who appeared before us, it's game over for judicial independence. Judges are going to look over their shoulders anytime there's a controversial ruling, and that's the last thing we want in this country. And so our independence was rewarded, and I don't think we're going to see another highly contentious, contested judicial retention election in this state for a very, very long time.
I was so encouraged by that. I mean, I sometimes worry if people understand why judicial independence is important. I mean, among other things, it means tolerating rulings that go against you and sometimes frustrate the democratic will or the will of the majority. And so for citizenry to understand that value, it takes a real level of kind of civic education, which I don't know that we always have in this country. So it worked in Arizona, but maybe Arizonans are more informed than the rest of us. How would you kind of quickly explain to an average citizen about why they should care about judicial independence?
Well, it's really judicial independence and the rule of law, as your organization is so aptly named, are really two sides to the same coin. This is a huge feature of Western exceptionalism. American exceptionalism is that we resolve our disputes not on the streets but in the courts of law, including some of the most contentious issues in our society. And we want to keep it that way. Even, as you say, even if we disagree, then vote for a different president who will appoint different judges, or a different governor who will appoint different judges. These things can change depending on the philosophy of the judge. And it's not just the big issues, but the small issues. If you have a property dispute, if you have a contract dispute, if you're a criminal defendant, you want to have judges who are independent and who will make their decisions based on the rule of law. This is the exception in the world. And it's not just the exception in Western countries. If you go to Mexico, Mexicans now elect judges at the same time as they elect their president. And they run together. And that is the last thing you want. In China, if you were convicted of a capital offense, and a lot of people don't realize how many capital offenses there are in China, including drug offenses, you go directly to a van that takes you for your execution. Do we want that kind of system here, in the United States? Of course not. Due process is expensive. It's time consuming. But it differentiates us from authoritarian regimes. And so that's why, we can't take it for granted. And judges, by and large, it doesn't matter whether it's a liberal judge or a conservative judge, we all care deeply about the rule of law. And so at the end of the day, I'll take my chances if I were accused of a crime in front of the most liberal American judge before I would take my chances in front of a judge in Mexico or Hungary when Viktor Orban was there, or Russia. It's very worth preserving, and unfortunately, most Americans take our system for granted. It's the way it's always been, and they assume it's the way it will always be, but it is always under attack.
So it's very much under attack, and there have been, waves, I guess, of attacks against the judiciary from our founding to today. But at least in my lifetime, I'm about to be 50. This is the worst I've ever seen, and it seems to be coming from every direction and from people who should know better. You have another essay you wrote last year about reckless rhetoric, talking about from mostly the administration and its allies, talking about judicial impeachment or ignoring rulings of the court. There's certainly threats from the left who talk about mostly focused on the Supreme Court, calling it illegitimate and worse. There's talk of court packing now. I mean, it's coming from everywhere. So first, I guess, do you rank these threats? I mean, what is most concerning to you? I mean, it's funny. If I travel in lots of diverse circles, and you go to a Federal Society event, you hear a lot of concern about threats to the Supreme Court. You hang out with liberals, and they're very upset about the attacks on the district courts, and you don't hear a lot of folks talking about both. So they're all a problem, but kind of which slice should worry us the most?
Well, and Greg, I hope you rank them, and I will put a lot of stock in how you rank them. But I hate to say this, but it almost depends on who holds the reins of power at any particular moment. You mentioned the court packing issue, which now has it seems to have become standard currency among people who are thinking of running for the Democratic nomination for president. And if we get court packing, if we get judges or justices chosen because of how they will decide cases, it is game over. It's likewise game over if judges are cowed into submission by threats by the administration, by the current administration. And so, we've just got to be eternally vigilant. And what I am hoping to see, I've got another article coming out around the end of the year, another law review article, but I know that there are people on both the left and the right who really care about the rule of law. And I think where we can find that the common denominator is on civil liberties issues and structural constitutional issues. And I've identified 4 in particular that I call the core 4, that I believe that most liberal advocates of the rule of law and most conservative advocates of the rule of law agree on very, very strongly. And there's 2 structural ones and 2 substantive ones, and they are federalism, separation of powers, freedom of speech, and due process. And they are the 4 core principles that we've got to defend against liberal overreach and conservative overreach. And if we can find, enough advocates in the middle, and that includes judges, but it includes nonprofit organizations that can only flourish in a free society. It includes people who wear a uniform or a badge, and it includes lawyers. Lawyers alone. It's the only private profession in our country that swears an oath to the Constitution. So I think lawyers in particular have to play a key role in really arguing for support for the rule of law, regardless of whose ox is being gored in a particular moment. So I guess the answer is I don't score the threats because really the threats are a function of how much ability a particular party or office public official has to effectuate what's going on, and so that changes over time.
So of those 4 principles: due process, federalism, freedom of speech, separation of powers. Are any of those under greater threat today than the others? I mean, I do think some could use a little more shoring up than others, but maybe you don't want to answer that question either. But
yeah, no, and they, I present recent examples of threats to all of them.
Okay.
But certainly, in this administration, due process right off the bat. You had Vice President Vance using air quotes as if due process, which is a right that pertains to all persons, not just citizens, by the language of the Fifth and 14th Amendments. We were talking about certain individuals who were faced with the most dramatic deprivations of liberty, not being entitled to due process. We were talking administration officials threatening that we might dispense with the writ of habeas corpus if courts didn't do the right thing. These are systemic threats to freedom. Free speech in both the last administration during COVID, during this administration, with colleges and universities, and dissenting viewpoints with regard to FCC licenses, really, really severe threats coming from both the right and the left. And of course, separation of powers. This is an area that the center-right thought that it had won in the U.S. Supreme Court, only to find, a Republican administration assailing it with the tariffs and other things. So, the threats are omnipresent. They come from both sides, and some of us have to cohere behind the neutral principles and defend them regardless of who the threats are coming from. And that's why I'm so delighted that the Society for the Rule of Law exists. The Federalist Society, and other organizations like that. Obviously, the Federalist Society doesn't take positions on issues or file amicus briefs and that sort of thing, but they certainly provide a forum for the debate over these ideas.
Speaking about some debate on the center right, I spent most of my adult life kind of in the conservative legal movement, and one thing I thought we all agreed on was originalism. Might have had different takes on it, but it was basically a common position, and it seems to be increasingly questioned amongst some folks on the right, maybe particularly after the birthright citizenship decision this term. There were a lot of attacks from self-described conservatives saying, if this is what originalism gets us, maybe we need to rethink originalism.
Yes.
What do you make of all this?
In a certain regard, Greg, I'm happy that it's getting smoked out, and that there are people who are coming forth and saying, maybe originalism wasn't such a good idea. And in fact, even before we get there, I think that originalism has evolved in a very negative way. Originalism used to be, in my view, textualism, and I am a huge textualist, and that's what I think originalism ought to be.
For the non-lawyers tuning in, can we give a quick
sorry
quick
about
gloss
that?
on
Yes.
originalism and textualism?
What that means is that you look, when you're interpreting constitutional text or statutory text, you look to the original public meaning of the words the people who voted on the statute or the constitutional provision used, the words that they agreed to. You don't look at what they really meant to say, but what they actually said. Why? Because that's the law. And you might look to some other tools if the language is ambiguous, but ultimately what you're looking to do is to define the words that are the law. Over the last couple of decades, most of the conservatives on the Supreme Court have attached themselves to a history and tradition analysis of what the words mean, and that can lead. First of all, it's far more subjective than textualism, and second of all, it can lead to very different results. Now we have some on the right saying originalism, if it gets you birthright citizenship, we need to abandon it, and we can because we own the courts, and we should use them for our own ends. And to me, if you've got a judge or a commentator or a scholar who never disagrees with the party in power, then you don't have a real constitutionalist. You don't have a real advocate of the rule of law. And I think the birthright citizenship case, which in my opinion was one of the easiest cases that has ever reached the court, and yet was a 5-4 decision. It really, I do think, has smoked people out because they're just so offended over the political ramifications. Would I vote for birthright citizenship if I were voting for a law or a constitutional provision? No. Do I think that the language of the 14th Amendment provides for birthright citizen? Yes, I do. And there's a way to change that. And it's not to change the judges, it's to change the constitutional provision. It's a lot of work, and people would like to short circuit that. But if they do, they are corroding the rule of law, in my opinion.
For all your, I should mention, we've mentioned a bunch of your writings throughout this conversation, and we'll certainly put links to them in the show notes. People should read them. I mean, you've been doing such great work. Before we wrap up our conversation today, I do want to ask you a couple of questions about your prior life before you donned a robe. You spent all this time as a public interest litigator in really high-impact cases that really helped shape the law, change the law in this country, and maybe the broader legal culture. Why is public interest litigation important in our system?
So, it goes back to the point I made earlier about resolving conflicts in the law, in the courtroom rather than on the streets. And public interest litigation is also a very American phenomenon. There are some other countries where there are public interest law firms, but they are really what made me go to law school. When I read about Thurgood Marshall's career leading up to Brown versus Board of Education, I'm like, that's what I want to do. And increasingly today, young people going to law school can do that for a living, because there are now, whereas when I went to law school, there were perhaps dozens of such organizations, there are now hundreds of such organizations. And, they take very, very sophisticated arguments to the U.S. Supreme Court. And as a result, many of the cases that we see are incredibly well litigated. They're thoughtfully litigated. It used to be that the big important cases would almost oftentimes be accidental. The lawyers that would bring them up, they just happen to be the right lawyer in the right case at the right time, and things are much more intentional now. And I think as a result, we get arguments that can lead to very, very very useful Supreme Court decisions. So to have had that as the major part of my career is just an incredible gift.
What is the role of for-profit law firms in all this with their pro bono work and maybe paid work? And particularly we're in an environment where maybe there's political pressure that some of these firms are feeling. How should we think about all that?
Yeah, so I have really loved seeing a growth in private firms of taking on these cases, either because they can find paying clients who can advance these causes, or doing it pro bono. Early in this administration, of course, we saw an attack on private firms, and an effort to either punish firms that had taken positions contrary to the past Trump administration, or trying to influence where firms would go with their litigation in the future. We had some firms that just capitulated, and we had other firms that really stood up for themselves. And then, we had some advocates, in particular, Paul Clement, who was who was thrown out of a big law firm because he litigated gun rights issues, only to turn around and represent these these firms against the pressure that was being exerted against them by the Trump administration. Now, there is a guy who supports the rule of law, and they won. The firms that took it on actually won, and I hope that teaches a valuable lesson. Again, the legal profession is at the front lines in these battles, and we've just got to be courageous.
So I think I'll ask you one final question. You have probably shaped the legal careers of lots of folks from this coast out to the West, both in lecturing in law schools, through people who've clerked for you or who you've mentored in various organizations. I, in the study of the rule of law, do a lot of work on law school campuses, speaking to young folks who are going to be new lawyers soon. What is one piece of advice you might give to a young lawyer, maybe particularly one who's interested in advancing the causes that we care about, such as the rule of law? How should they go about it? And particularly, one question I often get is: should they go to a big law firm first, or should they go to a public interest firm?
There's no one size fits all answer to that question. Obviously, if you've got the right grades and other credentials, clerking for a judge can be, enormously consequential, both for your own
don't forget
career.
About state Supreme Court justices.
Yes, exactly. But I will actually answer that question perhaps in somewhat of an unexpected way. We have a really outmoded provision in our state constitution that requires justices to retire at age 70. So I am facing mandatory retirement on Christmas Day of 2027, at which time I am going to start teaching full time. I teach a course in constitutional law every fall at ASU Law School, and I will, when I am obliged to leave here, since no one has taken that clause on as a constitutional matter, and I'm going to be a full-time teacher, and it's because I share what you said, in terms of really looking to young students as a future and as an important part of our future. And also, I will be starting a program on state constitutional law at ASU when I do that. But the advice that I do think is one size fits all is to throw yourself into it, to do as many internships as you possibly can, to become to join as many organizations as you can, and to really, that's how you find out where you can best make a difference, because it all depends on our individual skills, our individual passions, and you can't really figure that out until you've tried several things on for size. So I know that the Society for the Rule of Law is expanding its presence on campuses and law school campuses, and I hope that students will avail themselves of that opportunity and others, especially internships, where you can really, really immerse yourself and see what floats your boat.
Well, thank you so much today, Justice Bolick. It's been an honor and a pleasure. I really appreciate you joining us on Checks and Balances this week.
Gregg, thank you so much for having me, and all the best to you and your organization.
Well, thank you very much. For those of you tuning in, we'll be back next week. In the meantime, if you enjoyed this conversation and you also enjoy reading, which I understand some people still do, we have new content every week at our Checks and Balances Substack. If you enjoy being part of a community that values these conversations, please consider joining our sister organization, the Society for the Rule of Law. After we're done here today, please go over and leave us a review. It helps us get the word out and grow this podcast. You can follow the Society for the Rule of Law on Substack, YouTube, Twitter or X, Blue Sky, LinkedIn, and Facebook. Thank you all for joining us, and we will see you next week.